with one. Thank you. So, as I was saying, we would have done a number of the training sessions, and this one today came out, was one of the areas identified before, but then also participants on previous workshops and so on had asked about looking at the legal and regulatory compliance and so on that the organizations would need. So today, as I said, today's webinar is on legal compliance and is going to provide us, I am going to say us, with the opportunity to learn more from the Corporate Affairs and Intellectual Property Office and also from the Financial Intelligence Unit about the legal duties and obligations coming from the charities and nonprofits, those that are required. All right. I normally try to be short in my introduction so that we can really get into the presentations. So we're going to have first the presentation from KIPO. We have Ms. Boyce is here already, and then that is going to be followed by the presentation from the Financial Intelligence Unit. And then we're going to have the question and answer session. Now, this format, if you want to ask a question, you're going to have to raise your hand, or you can put something in the chat. We're going to try to monitor the chat also to look for questions and any comments that you might have there. So if it's if you're not hearing properly also, you can raise your hand and let us know, or put it in the chat and we will try to address that. So let me get into now to introducing Ms. Boyce. I was sorry, before I go to Ms. Boyce, there's only one last thing that I will be asking you all to do, and that's to fill out a very short evaluation form just before the end of the session. Okay, 4 questions, that's all. So let me now get to introducing Ms. Casey Boyce. Casey is an attorney at law. She was called to the bar in 2014 and is currently assigned to the Office of Corporate Affairs and Intellectual Property as the acting Deputy Registrar with responsibility for compliance and research. Since joining the office in December of 2020, she has served as Deputy Registrar of Companies and Project Manager on KIPO's digitization project. And she views these experiences as invaluable and enriching. Casey has worked in the private and public sector as a judicial assistant, Crown Counsel, and as a legal officer with the National Insurance Scheme and the Barbados Revenue Authority. She also interned in legal departments in various capacities in the areas of legal research and corporate governance. She believes that these work experiences have provided her with invaluable insight, which allowed her to work under various conditions and constraints, which fostered a keen interest in legal research and compliance. Now, she's a certified court annex mediator. She holds a Bachelor of Arts degree in history with a minor in linguistics. And from the University of the West Indies, she has a Bachelor of Law degree. And she also holds a master's in corporate and commercial law, again for the University of the West Indies. So I will finish there and welcome Casey to present. She's going to look at the obligations of the nonprofits and charities this morning. So welcome, Casey.
Good morning to everyone. I'm just going to let the acting registrar say a few opening comments before I get into my presentation.
Okay, thank you. Thank you, Casey. So we go over to Ms. Rochester, Tamisha Rochester, who's the registrar of KIPO.
Thank you and good morning, everyone. Welcome. We are pleased to be here to be able to present this session, which is very near and dear to our hearts, particularly because of all of the work we have been doing with the Financial Action Task Force. Primarily our mandate under Barbados's National Action Plan with regard to having certain measures in place to prevent money laundering and terrorist financing. So that is where I will start. Why are we here? How did we end up here, and what is the purpose of what we're doing? Now, Barbados would have undergone what is called a mutual evaluation report back in and please forgive me if I have the dates wrong, speaking off the top of my head. A few years ago, back in 2016, and our report came out in 2018. The report basically reviews each country on certain measures they have in place to prevent money laundering and terrorist financing. And coming out of that report, several deficiencies were identified. The report is conducted by the Financial Action Task Force globally, and Barbados with the Financial Action Task Force has agreed on certain measures, activities, and action items which it would put in place in order to mitigate that risk and to satisfy the recommendations of the FATF. Now, the FATF has several recommendations that span varying matters under the entire money laundering and terrorist financing scheme. What we are concerned with the nonprofit organizations would be recommendation 8, which refers directly to NPOs. And that recommendation is really to prevent nonprofit organizations from being used, abused, and misused by bad actors in order to support these nefarious activities. So let me make it clear, we are not saying that nonprofit organizations, by their nature, they are bad or they support any kind of illegal activity, money laundering, etc. But the reality is, when the FATF has conducted their different research and reviews, etc., these persons are using the nonprofit organizations, unbeknownst to them, to the NPOs, to be able to further their various causes. So I don't know how many of you know, with the 9/11 attacks, how many of you know that some of the money that supported those attacks and funded the terrorists went through the Bahamas, was not caught in the Bahamas system, and nonprofits were utilized in the transfer of that money. And this is what we are here for. And this is what our mandate requires, that we have these measures in place to prevent you from being misused, to prevent these persons from taking advantage of you because you have the status of a nonprofit company or charity to be able to support these types of activities. Now, unfortunately, I won't be able to stay for the entire session, which is why Miss Casey Boyce is here, and you are in capable hands with Miss Boyce, and she will walk you through basically what the requirements are with us in terms of after you've registered as a nonprofit or charity, what do you do next? And this is very important as well, because we find that a lot of entities, maybe they would have sought the services of an attorney or professional during the setup, but they really are not advised adequately as to what you do after you set up. And many of you don't know that there are a whole range of obligations that are set out, which you need to comply with. And these obligations certainly have been tightened because of the work we are doing with the FATF, and because of the global standards that are there, again, to prevent the nonprofits from being misused and to prevent that contribution to that illegal activity. So I invite you to sit back and enjoy the presentation by Ms. Boyce, and be sure to raise your queries at the end. And I know that the FIU will also have some very important information with regard to this. Thank you all very much.
Thank you, Ms. Rochester, for that very insightful perspective from Kaipor. And now we will turn over to Casey.
Hi, good morning again. Can you see my screen or can you see me?
I can see your screen. We just need to see your face a little bit more.
Yes, I'm having issues with the camera.
Okay, okay.
I would have to hold it,
Ah,
which is not convenient at this time.
But we can see the screen. We can
Okay.
continue.
Just give me a second to pull up the presentation on my view. Just a minute.
Good morning. While we're waiting on Casey, I am seeing a couple questions about the recording. Yes, the recording will be shared with participants. And you'll probably get that hopefully before the end of the week. And you're saying you're getting some feedback from Casey. So once she starts again, we'll see if that continues. And also from me, okay, the same Casey speaking is a bit of reverb. So let's see if that's correct when she starts again.
Can you hear me better now?
Yes, if you're saying the response, yes, it's much clearer.
Okay, so we'll begin here. So I'm going to start with charities first, and then we'll go into nonprofits. I don't know how many of the participants fall into which category, but I'll be speaking to both the obligations of charities and nonprofits. So the regulatory framework for charities includes these pieces of legislation that I have listed here: the Charities Act, the Trustee Act, the Trust Miscellaneous Provisions Act, and the Money Laundering and Financing of Terrorism Prevention and Control Act. So you've registered as a charity. Now what? What are your obligations? The first obligation that I want to point out is that all the property held by trustees shall immediately vest. Oh, sorry. Section 6A of the Charities Act provides that notice should be given to the registrar where there's a change in the registered details of the charity within 15 days of that change. So if there's a change to the name of the charity to the trustees of the charity, the number of trustees that are listed on record, the registered office of the charity changed, or the constitution has been amended, these changes must be recorded at the registry. And notice simply can be by letter, signed by the trustees, which is taken as confirmation of the change. So in circumstances where you want to change the name of the charity, you will include with a new registration certificate. So again, we have to have the required notice of that change so that you have the right certificate with the right name of the charity. Pursuant to section 6B, where the charities fail to give this notice, and again, you have to give this notice within 15 days that the change was made. If you don't, the registrar has the right to impose on the charity trustees a penalty of $100 for failure to comply with this section. Charities can also incorporate their board, and the board also has certain regulatory obligations that they must comply with. So all property held by trustees shall immediately vest in the board of trustees on its incorporation. Variation or changes to trusts on which the board holds property, or if any additional property becomes vested in the board on trust, not shown in the documents previously lodged with the registry at the time of incorporation, within 1 month of that property becoming vested or varied, notice should be given to the registrar. So this notice should include a copy of the documents showing the variation or the change, and or a statutory declaration by a member of the board setting out the variation. Additionally, if these requirements aren't met, each member of the board and each officer is guilty of an offense and liable on summary conviction to a fine of $5,000 and an additional fine of $500 for every day during which the default continues after the conviction is first obtained. So that this is a criminal offense to not meet this requirement. And once it is shown that you did not submit the required document, you are guilty and subject to this punishment. Pursuant to section 41 of the Act, trustees are required to furnish consecutive statements of account relating to a period of not more than 12 months to the registrar. Therefore, they are to be filed annually. These statements of account should include the income and expenditure expended for the reporting year and a balance sheet relating to the end of that period. Additionally, in accordance with section 42 of the Act, these statements of account are to be delivered to the registrar within 1 month of the 12-month period stipulated. So once 12 months have passed, you have an additional month in which to file your statement of account. Additionally, the registrar has the authority to require that the condition of the accounts of the charity are to be investigated and audited by an auditor chosen by the registrar. The expenses of any audit, including the remuneration of the auditor, shall be paid by the charity. And any person who fails to afford an auditor any facility to which he is entitled under subsection 4 is guilty of an offense and liable on summary conviction to a fine of $5,000 or to imprisonment for 6 months or to both, and to a further fine for every day or part thereof that the offense continues after a conviction is first obtained. A charity may be removed from the register for inactivity or being in default. Instances of default include where the trustees have failed to furnish the registrar with the statements of account as set out in the previous slide, and where it appears that there has been a change in the purposes of the charity, such that the activities of the charity are no longer to be considered or fall within the definition of a charitable purpose as outlined in sections 3 of the Charities Act. So the effect of removal from the register for a charity is that the charity essentially ceases to have the status of a registered entity. Therefore, if a charity has been removed from the register and attempts to continue to operate effectively unregistered, it is acting illegally. If the charity continues to operate without registering in accordance with Section 5 of the Charities Act, they are liable on summary conviction to a fine of $5,000 or to imprisonment of 6 months or to both, and an additional fine of $500 for every day or part thereof the offense continues. So that is the liability of the charity trustee. Further, a charity trustee is not entitled to claim any tax exemptions under any enactment in respect of the charity for the income year during which the charity remain unregistered. This provision also applies to charities that are operating without ever being registered. The supervisory role of the Attorney General, who has oversight of charitable trusts. The Attorney General has the authority to examine and inquire into any trust for charitable purposes in Barbados, and examine and inquire into the nature and objects, administration, management of the charity. I just want to pause here to say as well that all charities are trusts, so that the legislation relative to trustees and trusts that I would have pointed out in one of the first slides, that is why they would apply to charities. So all charities are trusts, and the Attorney General has the authority and oversight to see how these charitable trusts are managed. The AG may also examine and inquire as to the value, condition, management, and application of the property and income belonging to the charity. These investigations are carried out for the purpose of, if the charity, any charity is suspected of having committed an offense under Section 3 or 4 of the Anti-Terrorism Act. I'm sure when we get to Mr. Rollins' presentation, you will see the links as we get into the discussion about the anti-money laundering and anti-terrorism pieces of legislation. Any person who fails to comply in respect of any examination or inquiry referred to is guilty of an offense and liable on summary conviction to a fine of $5,000 or imprisonment for 6 months, an additional fine of $500 for every day the offense continues after a conviction is first obtained. As stated at the beginning of the presentation, the registrar has regulatory authority for ensuring that charities are in compliance with the Act. Therefore, any person who fails to make full disclosure to the registrar of all material facts required to be disclosed under the Act, or who makes a false statement of a material fact, or makes a statement containing information that is misleading in light of the circumstances in which it was made, they are guilty of an offense and liable on summary conviction to a fine of $5,000 or to imprisonment for 6 months or to both, and to a further fine of $500 for every day or part thereof that the offense continues after a conviction is first obtained. So again, I just want to highlight before I go into nonprofits, some of the key provisions that charities really need to pay attention to. I would say that after an intensive review of the charities on register, it appears as though a significant number have failed to file statements of account. Now, this is an issue because it represents a large portion of charities that are non-compliant with the legislation. So again, I want to remind you that you must file statements of account, and you are supposed to keep all of these accounts on your books and statement and your financial records at least for 7 months. So if you've been in operation for 10 years or more, and you know that you have not filed statements of account ever, please note that you're in default of the legislation, and we urge you to come and correct your records. So if there also, I want to highlight that if there are any changes made to the composition of the charity, notice is to be given to the registrar. We just want to move into the section on nonprofits. Nonprofit entities are governed by the Companies Act of Barbados, Cap 308. A nonprofit is considered to be a company without share capital. So that is the real distinction between a nonprofit and the charity. The legal ending of a nonprofit is Inc. It has directors, articles of incorporation, bylaws, and so on. So that is why they fall under Companies Act, because they're treated as a company without share capital. As such, they're required to file certain documents regularly, and we will look at some of those particular filings. Once incorporated, and a nonprofit is expected to have its first annual general meeting within the first 18 months of its existence, and subsequently not later than 15 months after holding the last preceding annual meeting. And my next slide will explain why the timing of your annual general meeting is important, or so important that it is dictated in the legislation. Pursuant to Section 323D of the Companies Act, a nonprofit company must, within 15 days after its annual general meeting, send to the registrar a copy of its annual financial statement. The statement should include a balance sheet representing the assets and liabilities of the company, the revenue and expenditure of the company since the date of incorporation or the previous date of its previous financial statement, the names of donors where donation exceeds $20,000, and where the donor is an entity, the individual or individuals who beneficially own and control that entity, those names must be given. A report from the auditor of the company, and a report from the auditor of the company. The directors of the company are to approve the financial statements, which is evidenced by one or more directors' signature on the financial statement. So where a person fails to file these financial statements as required by the previous slide, they are guilty of an offense and liable on summary conviction to a fine of $5,000 or to imprisonment for 6 months or to both, and to a further fine of $500 for every day or part thereof that the offense continues after conviction first obtained. So it's the directors that bear this liability. So in addition to filing audited financial statements, a nonprofit is also expected to file a domestic annual return in accordance with Section 15A of the Companies Act. A nonprofit incorporated between the 1st of January and 30th of June is required to file their annual return for the previous year by June 30th succeeding year. And those incorporated between the 1st of July and the 31st of December is required to file the annual return by the 31st of December. However, if you can provide all the information required in the annual return before the statutory deadline, you can go ahead and file it. So in addition to filing your annual return, the nonprofit also has to file an annual financial statement, which should be audited. I hope that was clear from those requirements that I set out in the previous slide. Your financial statements are to be audited and signed by the directors. You're also supposed to provide your domestic annual return. So an NPO that is in default in complying with the requirements to file the annual return is liable to a penalty not exceeding $3,000 of $10 payable to the registrar for every day during which the default continues. And I just want to point out here that this provision is being strictly applied. So that if you have failed to file an annual return for successive periods, it means that you owe $3,000 for every year that you have failed to file. Every director and officer of the nonprofit who knowingly and willingly authorizes or permits the default is also liable to this penalty. And for the last 2 years, I'll share with you that for the last 2 years or so, KIPO has been concentrating on cleaning up the register. And this would include the activity of striking off inactive entities from the register, and largely because they've been found to be in default of filing annual returns. So if there are entities that we find on the register that are not filing, for example, as I said, their annual returns for consecutive periods, it will be struck from the register if no action is made to correct the default. That is, pay the penalties and file the documents. Where there change in the composition of the directors of the nonprofit, within 15 days of that change you are expected to file with the registrar a notice that contains the particulars of that change. And since there are already statutory forms available, you're expected to file a Form 9. The notice of change of directors may be filed. Failure to file this notice, and I can say that I've come across many nonprofits that have failed to give notice of the change of directors. And they find themselves in this situation of having to pay the penalty of $100 for every day during which the default continues. And this is what the legislation says. This is not what KIPO came up with. The failure to file the notice of the change of directors renders the nonprofit in default and liable to a penalty of $100 for every day during which the default continues. Every director and officer of the nonprofit who knowingly and willfully authorizes or permits the default is also liable to that penalty. The registrar may also require that the condition of the accounts of the nonprofit be investigated by an auditor appointed by her. The auditor appointed has the right to access all the books, accounts, documents relating to the nonprofit that are in the possession at the registered office of the nonprofit or under the control of its directors. The expenses of the audit, including the remuneration of the auditor, are to be paid by the nonprofit. A person who fails to afford an auditor any facility to which he is entitled is guilty of an offense. The penalty is summary conviction, a fine of $5,000 or to imprisonment of 6 months or to both, and to a further fine of $500 for every day or part thereof that the offense continues after a conviction is first obtained. So that's the end of the slides. Again, I would point out for nonprofits, the key regulatory provisions, bearing in mind that the company aspects of the Companies Act will apply to nonprofits because they're treated as a company without share capital. Audited financial statements are to be filed. within 1 month of the annual general meeting, and domestic annual returns to be filed by the 31st of December or the 30th of June, depending on the incorporation date of the nonprofit. Additionally, if there are changes to directors, you must posit that notice of change within 15 days of the date of the change, or you're subject to the penalty of $100 a day until you rectify that issue. And that runs, it doesn't have a stop. That $100 just runs and runs until you rectify the default. So I will give way to Mr. Rollins to go into his presentation. And if you have any questions, when he's finished, you can, you can ask them in the chat or raise your hand and I'll try to answer them. Thank you.
Thank you. Thank you very much, Christy. Okay, so now let me introduce Mr. Rollins. And as Casey said, I see there are a number of questions that came up in the chat already. And we are making a note so we can get back to those at the end. And Casey she can take a look at them now, so she'll be able to answer. So let me introduce Mr. Rollins. Roger Rollins, he was a member of the Royal Barbados Police Force. I think it's the Barbados Police Service, the new name. For 21 years, he joined the organization in 1985. And during that time, he worked with various divisions, performing operational functions, as well as within the research and planning department. He was also staff sergeant to a number of assistant commissioners of police and the deputy commissioner of police. His last posting was with the service was at the Regional Police Training Center as an instructor. In 2006, he joined the Financial Intelligence Unit as an analyst, and since then has represented Barbados at a number of international conferences and seminars on money laundering and terrorist financing. Additionally, he has received extensive training in the aforementioned subjects. Roger holds a Bachelor of Arts degree in history and is a certified anti-money laundering specialist. He's also a trained assessor in the Financial Action Task Force for 4th round of anti-money laundering / the Caribbean Financial Task Force mutual evaluation, and a strategic analyst trainer for the Caribbean Financial Action Task Force region. He's an ardent cricket fan and played the game with much passion. That passion never amounted to much success, as he proved to be more of a burden than an asset to the teams he represented. Now, these are Roger's words. He said, however, he played on a number of championship winning teams, even though he never contributed much to even though his contribution to the victories remain questionable. So in addition to any questions you might have for him on the money laundering and terrorist financing, you can also ask him any questions about his cricketing or lack thereof. So over to you, Mr. Rollins.
Good morning, everyone. Thank you, Ms. Farley. And let me say on behalf of the director of the FIU, Mr. Kirk Tate, I want to thank you for giving us this opportunity to explain what is expected of the charities and nonprofit organizations in terms of interacting with the FIU. Now, just give me a minute. Let me share my screen And bear in mind, if anything goes wrong, it is really not my fault. I would have tried my best. When it comes to technology, I may be a big challenge. I hope that everyone can see my screen and that you can hear me clearly. Now, before we go any further, I can't take credit for work that I did not do. So these slides that you see here are the slides that you'll be seeing that look, in my opinion, very good, not my work. The words may be mine, but the slides were done by our research officer, Mr. Darian Farley, so I have to give credit for his work. Today, we're going to be looking at the obligations of charities and nonprofit organizations in terms of combating terrorist financing. Even though the presentation states we're looking at the charities and nonprofit organizations in relation to terrorist financing, we've also included money laundering and proliferation, because out of charities and nonprofit organizations, that would be those two offenses also appear. So we'll just be giving you a brief definition on those. Okay, the overview, we're looking, like I said, at the money laundering, terrorist financing, and proliferation financing, the stages of those three offenses, the Financial Action Task Force, the Caribbean Financial Action Task Force, the penalties for persons who choose to flaunt the Money Laundering and Terrorist Financing Act, reporting what we know as what we call suspicious transactions, and we're talking about suspicious or unusual transactions. We're looking at recommendation 8, as was mentioned earlier by Mr. Tester, in terms of the recommendations by the FATF, the Financial Intelligence Unit of itself, and what we do, red flags and indicators that would tend to suggest that a person may, note what I said, may, and this may is not mandatory. A person may be doing something that is wrong and may involve terrorist financing. And then we'll also look at some case studies. So away we go. Now, this is our disclaimer. We are just informing you of these offenses. We are not telling you how to commit these offenses or encouraging you to do it. So if you do something that you're not supposed to do and you had to end up in trouble, you can't say that Roger Rollins taught you how to do this a Wednesday morning way back in August 2023. Now, terrorist financing. Terrorist financing is actually, the definition is there, but it's actually providing funds to assist terrorists to carry out the act. So you actually have what is the terrorist act, the performing, let's say, the bombing of let's lose an aircraft, the bombing the aircraft, the actual terrorist act. But the terrorist financing is the money that would have been provided to assist the terrorists in terms of carrying out that act. So that is what we are looking at, the terrorist financing. So if you cut off the terrorist financing, then the chances of the act being perpetrated is minimized. And it's broken down basically into 5 stages. You have the acquisition, the aggregation, transmission to the organization, then to the cell, and the conversion. And the acquisition is in terms of acquiring this money. And you all are familiar with you all are into
Good
charity.
morning. Good morning. Hi, Roger.
Yes, please.
Right. We are just seeing your the screen. You're still on the first slide. Can you
Okay, all right. Let me
put it in slide view and
slide view.
Because from here I am seeing it in slide. Okay, just give me a moment.
okay. into advance.
Can you see the slides now?
I am saying it in the same,
It's still at the first slide?
yeah, it's still at the first and it's still in. You just need to
Alright, it's
change the
still-
view.
All right, just give me one moment. I've sent for my IT technician, as I would have said earlier.
Yes, you did the disclaimer early.
Yes. So please bear with me, ladies and gentlemen, for 1 minute. I will try my best until the person gets here.
Should not view so much. Should not view and present the view.
Okay.
Hmm. Okay, hello everyone. Well, we're waiting on Roger to get his issues sorted. I see KC has responded to one of the questions that was in the chat and that was regarding if do you accept the e-signatures? Please say where the code is required, where code is required for electronic signatures. No, we do not have the facility to authenticate the signature. However, if a digital document is loaded, we accept them. Okay. Okay.
Okay.
All right. Good, Ms. Farley, I am back. I am hoping that you'd have seen the screen changed.
I am seeing the same screen here.
Still the first slide.
Still at the first slide. Let's see. Okay, somebody say you need to stop sharing and then share again. Okay, now I see the change.
Okay,
I'm seeing the
you
change.
see the change?
Mhm.
Okay.
All right.
Okay, you're seeing the disclaimer? You're seeing the disclaimer?
The terrorist. Yes,
Okay.
yes,
And the definition and the
definition,
stages?
yes. Yes, so
Okay.
you're good to go.
Okay, all right. Let me apologize for that. And those people who are in my age bracket would know of the term monkey handling gun. So please accept my apologies once again. All right, as I was saying, in terms of the stages of terrorist financing, you're looking at the acquisition, and this is where the persons out there solicit money for the financing of the particular act that they want to carry out. And they may do it in a legitimate way using a charity. But let me use the term NPO. Let me use an NPO. So for example, you would probably see on television from time to time, the cable channels, those charities that will offer, okay, they're saying to you, $20 a month will supply, will feed a child for X a month. And the pictures that you're seeing, that it sort of tug at your heart. And you say, okay, I need to supply this money. But even, let us look now in a Barbadian context. Say, for example, St. Philip decides that it wants to be liberated from Barbados and it wants its own independence. They would approach the authorities who bluntly refused. So as a matter, what they did, they formed these freedom fighters who will fight for this independence. So they go out there, genuinely, they would solicit using another cause, or in some instances, some people who may believe that St. Philip should be independent would donate to the cause. And then you have the other side of it, where the criminal aspect, where they get involved in drug trafficking, robberies or kidnapping and so on to get this money. So then you move to the aggregation, where the money is pooled together. And once it is pulled together, it goes to the terrorist organization, and it may not necessarily go through the bank. All may not necessarily go through the banking system, but it may go through cash couriers in terms of cross-border transportation of the money. So it then moves to is transmitted to the operational cell, and the cell would then divide it up in terms of convert to whatever is supposed they need, either to make bomb-making materials, to buy weapons, or in some cases where it is converted to support the children of those fighters who might die for the cause, or those persons who are familiarly known as the suicide bombers. Money laundering, this is defined in terms of money that was acquired illegally, where you try to get this money into the system, and it is then, when it comes back out, it appears to be clean, that you would have legitimately earned this money. Point to note, you cannot launder money that you legitimately came by. If you, for example, you would have inherited property and you don't want, sorry, you'd have inherited $500,000 and you don't want your spouse to know, you decide to split it up and move it from point A to point B and another set to point C. Once it's legitimately obtained as your money, you can do whatever you want to do with it. But if it is legally obtained, that is where the problem comes. You can only launder money that has been illegally obtained. And the purpose of the laundering money, what launderers will do, the money will eventually return to them. And it returns, whether it is returned in cash of itself, or it may be returned in terms of property and so on. The money is circular as it relates to money laundering. For terrorist financing, it's linear. You give the money and then it goes away. It never comes back to you. The money laundering, we have the 3 stages: placement, layering, and integration. The placement is where you would have acquired this money, let's say, through illegal drugs, the sale of illegal drugs, and you get it into the banking system. Once you get it into the system, what you do now, you can either add to that or move it from one financial institution to another financial institution. When it comes back out now, when you determine, well, look, this money was inside the bank, I've moved it, the tracing of it is pretty difficult, and you integrate it, it appears as though it is legitimate money. For money laundering is mainly historical, because the offense would have been committed already, where you would have laundered the money, or you're in the process of, well, yeah, you would have laundered the money already. So the authorities are actually backtracking, and it technically is reactive. For terrorist financing, it is more proactive, because you see the money may be moving, and you are trying to get to the end of the money, or where the money is supposed to end. You're trying to get there before the money actually gets to that point, and you want to stop the particular act that the persons want to perpetrate. Now, proliferation, yes, all of these, this long definition, providing funds or financial services for the manufacture, acquisition, possession, development, export, and terms of chemical, biological weapons. All of this definition, all this is simply saying to you, talking about weapons of mass destruction. So whether you're providing funds in order to make, to acquire, to send whatever weapons of mass destruction, this is known as finance proliferation. And the problem with proliferation financing is that it is difficult to detect, because persons use what they do, things that they order or use the money to purchase are things that people would normally purchase. So let's say in an industrial setting. So when you see the particular products that they purchase, you may naturally say, okay, this is something that may be used, for example, in information technology. So it looks that way. So it is a lot more difficult to identify. Financing and money laundering, there are 3 stages where you have the program funding sources, and the countries that they mainly look at in terms of this is North Korea and Iran, in terms of where they have programs in terms for specifically for funding this type of offense, as it would be termed. So the money is provided. They have fundraisers. Again, people may donate to the cause, and to move the money again, you're going to disguise this particular the money, so you don't know that it actually, let's say, it came from Iran, or somebody supporting Iran would have provided this money. So it's disguised in some instances as money purchasing what appear to be legitimate things. Now, once they would have gotten the money into the system, it comes back out, and they are going to purchase the materials and the technology. However, sometimes what the authorities discover, that instead of, let's say, a container shipping, when they look at the container, when they look at the bill of lading, I think that is what is. I can't remember the exact name of it, but the documentation on file, and when they do an inspection, is totally different to what they actually find. So that is one way of discovering and curtailing the movement of the materials that they would have purchased. Mr. Rochester touched a bit on the FATF, or I should have said there are a lot of acronyms and abbreviations in this sphere of the world. So please bear with me if I go into acronym and I don't say what it is. If someone wants to raise it in the chat, they can do that, and I will happily say what it is. But the FATF, the Financial Action Task Force, initially they were created to deal with to protect the financial system from money laundering. Subsequently, terrorist financing and finance proliferation, those two were also added. And what they did, they were formed in 1989, the FATF, and what they did, they came up with recommendations. And throughout the years, they would have amended the recommendations. And I think the last edition in terms would have been, I think, 2012, where there are 40 recommendations. So these recommendations deal with terrorist financing, money laundering, and finance proliferation. And as Mr. Rochester said earlier, Barbados had a mutual evaluation based on these 40 recommendations in 2016. Now, the Caribbean Financial Action Task Force based in Trinidad, they would be the person, that is the body that's responsible for conducting the assessment. And they are an affiliate body of an associate body of the FATF. And there are a number of associate bodies. They are divided into the various regions throughout the world. Y'all can still see the slides changing?
Yes, yes.
Okay, all right, thanks. Now, the legislative framework coming out of the FATF, what they would have, these 40 recommendations. And yes, it's termed as, the term as recommendations, but let's say that is more international law than recommendations, because even though you term it recommendation, there are severe consequences for not implementing these recommendations. If I recommend to you, give me your half of your salary every month, it's a recommendation. You don't have to, but for the FATF, if they recommend you do X or Y, is seen as a must. So these pieces of legislation would be within the regulatory framework that we operate in as it relates to terrorist financing. You have the Drug Abuse Act, Proceeds and Instrumentalities of Crime Act, Mutual Assistance Act, the Anti-Terrorism, Counter-Proliferation of Weapons of Mass Destruction Act. Yes, that was changed. The name was changed from the Anti-Terrorism Act to that, what you see there in 2019. The MLFTA, Money Laundering and Financing of Terrorism Prevention and Control Act, that is the act that would have created the FIU, is also the act that places certain obligations on NPOs, and we'll be coming to that. The Criminal Assets Recovery Fund Act, and also a guideline for charities and nonprofit organizations that would have been issued by AMLA, the Anti-Money Laundering Authority. This is the body that is responsible for the advising government in relation to the policies that they should implement in terms of targeting money laundering, terrorist financing, and proliferation financing. This guideline, if you want to see this guideline, I do recommend that you should look at it. You can, it's on our website. I think it's barbadosfiu.gov.bb. So you can go there and download it, and makes interesting reading. Now, the penalties for money laundering. Now, $200,000, 5 years if you go to the Magistrates Court, the High Court, $2 million or 25 years imprisonment, or both. Now, bear in mind that these are the maximum. Is not saying that a person may necessarily get this, but these are the maximum penalties. If you provide assistance, $150,000, 4 years imprisonment. At the lower court and at the High Court, 1.5 million imprisonment for 15 years. And in all the instances are both. In relation to terrorist financing and proliferation financing, the principal offender gets 30 years. And if you decide you will provide assistance to this principal offender, you will also get 30 years. Note that there is no monetary penalty there. It is prison if you decide to do that. Okay, Mr. Rochester spoke about the FATF's recommendation 8, and it deals with the nonprofit organizations. And in essence, the points that a country and the regulatory authorities, they're supposed to review all laws and regulations as it relates to nonprofit organizations and apply focus and proportionate measures in line with the risk-based approach. And all of this is and this is a précis of the actual recommendation, and it is to protect from the terrorist financing abuse by the terrorist organizations who from time to time they pose as being legitimate entities, and by exploiting legitimate entities as conduits for terrorist financing, and by concealing or obscuring the clandestine diversion of funds intended for legitimate purposes to terrorist organizations. So what these 3 points are doing is trying to curtail the activities of the terrorist organizations. So if they're posing as a legal entity, they want you to weed them out. If they have, for example, a known terrorist or an organization, they have property or so in your country, it is expected that the country is to freeze these assets. They are not supposed to allow the individual or the organization to have access to these assets. And the definition of a nonprofit organization, now this is taken strictly from the interpretive note of recommendation 8. It embodies what the FATF sees as a nonprofit organization, and it lumps the charitable organization there. So it's a legal person or arrangement or organization that primarily engages in raising or disbursing funds for purposes such as charitable, religious, cultural, educational, social, or fraternal purposes, or for the carrying out of other types of good works. Now, my interpretation of this is that this is pretty broad. When you look at, when you get into the types of other types of good works, now that is open to interpretation. So what this definition appears to do is to capture the entire framework as it relates to NPOs. However, there is a sort of a, I don't know if to say it is a silver lining, because what you're supposed to do, it does not apply to every single charity. If you look at what they really refer to as the risk-based approach, and what you need to do is to identify the risks, and this is what the risk-based approach is about. You identify the risks that the terrorist financing and so on pose to your particular charity, well, your particular NPO. And once you identify, you assess these risks, what you need to do, put measures in place to manage or mitigate the risk. It is similar to a house. You would have built your house, you would have spent how much ever thousands in this house. So you are looking now to protect your house. So you look at the risk and to your house, you realize, you know what, my windows are pretty close to the ground. Somebody can break the window and reach in or climb in. So what you do, you put burglar bars there. Maybe you decide that you use the cameras. So it is similar to that, where you look at your risk. You may determine, well, I live in a gated community, so there's no need for me to use burglar bars at my windows. So you look, that is how the risk-based approach operates. You look at the risk that is there, and then you put measures in place to target the particular the risk. And as at a minimum, charities and NPOs should have, and some of this comes out of your the act that Ms. Boyce would have alluded to earlier, where you have adequate records of the receipt and use of funds and of the decisions made regarding the operations. The adequate financial and internal controls, and you have to make sure that the funds are properly accounted for. And if you are funding, let's say, funding for stray animals, now you should have things that will be in place that when you look at your financials, you'll be able to say, okay, X or Y went to, maybe you had to rescue a stray animal. You may have to provide in terms of providing food and so on for the animals. The adequate due diligence, monitoring the use of funds, procedures in place for undertaking their legal responsibilities. Again, that was mentioned earlier, taking reasonable steps and appropriate steps, and carried out the necessary steps to identify who are the beneficiaries, especially where the risk is considered high. So You should not be just simply, for example, you are collecting, and just use this case, a war-torn area. Let's say a war-torn area, and you're sending money. Your charity is raising money to send to this particular area. Now, you should know the beneficiaries, whether it is going, it may be saying it's going for children to assist children who would have lost the parents in conflict, or maybe fighters who would have been injured and they no longer have the use of all the faculties. So you may be raising money for these causes, but you need to make sure that the beneficiaries are actually persons that who say they are. And similar to the banks in turn, the commercial banks and credit unions, they're supposed to know their customer. You're expected to know your donor. So if people are donating money to you, you should know the donor. Now, hold a moment, because I know persons will say, well, I need to know everything, but no, you don't. All those persons who, and when you do, you look at your risk. When you look at the donor, for example, you are running a charity where you're feeding homeless persons. Your money may be coming from Barbados, Barbadians who will say, okay, hold on to this this money. Yeah, when you look at it, you say, okay, this is low, because you are receiving money from persons to use here in Barbados. But from the time you start getting money from overseas, say someone is overseas, you still have to do your checks and balances so that you know who that individual is, especially when the donations, some people may send to you, let's say $20,000, say, okay, you can use it. But then the other side of it is, if you are required to take that money after the donor will send it to you, and the donor asks you to, okay, send back a portion of this money to me, or send a portion of this money to another account. I mentioned earlier in terms of know your beneficiaries, and again, know your partner. And if you may be in partnership with other charities, the home of the charity maybe, let's say, in Europe, and you may be working in conjunction with that particular individual. You need to know exactly what that individual is doing in terms of where the money is coming from. Now, in Barbados, we have a number of organizations who will provide, let's say, parks for a community, play a part within the community. Now, they may partner with other agencies within Barbados to go about this and play a part. Now, a reputable agency that you don't have to do the due diligence as it relates to that particular individual. We're looking at primarily your partner. If the partner, you don't know anything about the partner, or for example, you realize, look, what this partner is telling me, it does not make sense. Partner is saying that we can assist you in providing X or Y, but when you look at it, they're sending more money than what is needed to complete, let's say, the particular project. All right. A special category of persons that you need to know about, the politically exposed persons. And these are persons who are entrusted with high prominent positions within the country and public functions. And we are looking at the persons like the Prime Minister, the members of cabinet, the permanent secretaries, departmental heads of various missions. Now, that is the domestic PEP. When you are looking at persons who are in your country, like I said, the Prime Minister and so on. The foreign PEP will be those persons who come into your country and work. for example, the head of PAHO, the head of who is in charge of the Food and Agriculture Organization, those persons will be considered as foreign PEPs. Additionally, it extends to the family of these persons and their friends. So if you are, let's say, a permanent secretary in Barbados, your child would also be looked upon as a PEP in addition to you. So these are people that you need to, well, not that you don't do business with them, or you don't, you say, look, I don't want you supporting my charity, but in terms of working with them, you do a little more, you're a little extra more cautious, if I think that's the correct way to put it, that we're more cautious in terms of where the money that they're supplying to you, where this money is coming from. Not saying that you don't do business with these people, and just telling you that you do a little extra care. You're a little more, a little extra careful. The reporting of unusual or suspicious transactions, and this falls under Section 23 of the MLFTA, and you fall within this particular category. A financial institution shall monitor and report promptly to the director any transaction where it is reasonably suspected that is reasonably suspected. It does not say that you have to have concrete evidence where that to put before a court of law that is something is happening. Where the transaction is involves the proceeds of crime, we believe there's some criminal aspect to it, involves the financing of terrorism, is of a suspicious and unusual nature, or conducted by or relates to a person against whom a terrorist designation order or counter-proliferation order is enforced, or relates to the property of such a person. Remember, I spoke earlier of persons who you're not supposed to do business with. This relates to those individuals where there's a consolidated list that the United Nations updates on let's say on a basis of if somebody they need to add an individual or an organization, that list, this refers to persons on that list. So if you had to get a donation coming from, let's say Roger Rollins' name is on that list, and you had to get a donation coming from Roger Rollins, you should immediately file this, what we call a suspicious transaction report. And this is in essence is what this is, an STR, where you would say, okay, you will give us the details of the transaction and what the person actually doing, and information in relation to that particular individual. It goes on to also say if there's any exchange of currency or instructions to transfer international funds, whether by telegraph or wire, into or out of Barbados, and the transaction appeared to be suspicious or unusual. Now, you are Section 48 of the MLFTA, you're immune from being sued once you are reporting within your duties. And why should you file the suspicious transaction report? It assists in criminal investigations and prosecutions, provides trends and typologies, and we can tell you, okay, what we are seeing in within the sector, the various sectors that we have a look into, because once an institution files an STR, we look at the STR and then we can share it with the other financial institutions and the public in general. For example, one that is, I'll give you this, we would get STRs in terms of persons using fraudulent documents. So when we get, for example, let's use, for example, Barbados, the new Barbados ID. No, not the Barbados ID, the passport. Say, for example, a financial institution realized that somehow persons out there are using they would be able to come up with a fraudulent Barbados passport, and the person is using it. Now they're aware, they provide it to us. We inform our counterparts, and it is out there that okay, when persons are producing the Barbados passport as a form of ID, that you have to be careful just to make sure that what the person is providing is actually an official document. And it helps with public awareness of MLFT. Like you said, you inform of the trends and typologies, and it IDs the weaknesses in the financial system, because the truth is, persons will always try to trick the system. So if you can just get a foot ahead of them, that will be better for us and Barbados as a whole. The definition of the FIU, and this is required by law, is a central national agency responsible for receiving and, as permitted, requesting. Now, some entities can only request if an STR would have been filed on a person. That does not apply to Barbados. We can ask for information from financial institutions, whether or not we would have received an STR on that person. And you're responsible for receiving these STRs, analyze the STR, disseminate to competent authorities disclosures of financial information. And when we talk about competent authorities, we are looking at, for example, maybe a regulator in Barbados, law enforcement in Barbados, or our counterparts outside of Barbados, other FIUs outside of Barbados. And these STRs refers to suspected proceeds of crime and potential financing of tourism, and is required by legislation. Now, you see the definition is taken from the Egmont Group. That's the international group that oversees the FIUs. And the FIU is at the center of this diagram here, where you see, for example, we receive an STR from the financial institution. You see there's the NFBP, that's designated non-financial business person, and that refers to individuals, lawyers, accountants, attorneys, trust and service providers, real estate agents, and dealers in precious metals. They are considered as financial institutions when they are doing certain types of business. All right, so we receive that information, the STR. So what we do, we analyze it. We may decide to request information from somewhere else, whether here in Barbados or overseas. And once we get back that information, we can, and it's worth disseminating. We disseminate it to, you see here, foreign FIUs, law enforcement, tax authorities, and supervisors. Now, the FIU was formed in 2000. The current director is Mr. Kirk Tate. Our FIU is an administrative FIU. There are 4 types of FIUs. You have in terms of the administrative FIUs, we don't have the power of to go and arrest persons. We are in a position where we ask for information and we can pass that on to law enforcement. Then you have the law enforcement type FIU. Then you have the prosecutorial type of FIU, where you have a judge who is in charge of the FIU. And then the 4th type will be a combination of the 3. Maybe you may have an admin and a prosecutorial, and so on. The majority of countries would have gravitated to the administrative type of FIU. The red flags and indicators, these are things that would tend to suggest that maybe terrorist financing is occurring, or the person is doing something wrong. It's not necessarily saying that the person is actually doing something wrong. It sort of makes you think and say, well, okay, this doesn't look right. It's just like, For example, you get up one morning, you have a headache, and your nose is running, and you sneezing, and then you start coughing, and you may say, "Oh, I coming out with the flu." That's an indicator. Or you get up and you have joint pains, the back of your eyes hurting. You say, "You know what? These are the symptoms of dengue," but you are not certain. All right. So it's the same way with the red flags and indicators. And just to give you these few in terms as it relates to your particular industry. And the NPO sending funds to multiple entities in high-risk countries. And you can normally find this in what they call conflict areas, that persons, no apparent reason, sending money to persons in conflict areas. The NPO use crowdfunding and social media to get donations, and then all of a sudden, you don't hear anything of it anymore. Now, truth is, yes, it may be terrorist financing, and then it may be money laundering, because some of those persons, some persons create charities, create charities in order to steal money from people. They tell you, okay, we're asking you to donate to X or Y cause, but at the end of the day, they don't, is not used for the particular cause, and actually they use it as money that go and buy things for themselves. NPO funds commingle with personal / private or business funds, where, for example, you find that money may come to the NPO, and one of the persons responsible for the NPO at the financial institution, that is signing authority at the institution, you find that they're moving money from the NPO to their private account, or back and forth in terms of sending the NPO and so on. But if you are using money, if you have the NPO, you would have to tell me how likely it is that you will be using your personal account to transact business and so on for the particular NPO. Donations are received from unknown or anonymous bodies. Yes, this can happen, but at the end of the day, in situations where you may believe in some instances something is not right, yes, you may need the money, but you still need to be careful. Beneficiaries, with identical characteristics and addresses are multiple, identical, similar names and signatures, where every one, it looks as though, yes, on the face of it, they're different people, but maybe, you know what, when we look at the information that's coming through, and also the writing and signatures, they all look alike, so it may be one person. The structure of or nature of the proposed project makes it difficult to identify the partner and verify the identity and details. So if you are working with an individual, you need to be able, a particular partner in doing something, you need to make sure that you know all you can about the particular partner. It's difficult to contact the partner at their main address, or the telephone numbers are not working. And that's straightforward of itself. Repeated excuses of system crashing, losing records or paperwork. Yes, systems do crash, but it happens all the time. Something may be wrong. Offers for monitoring to be carried out by friends or known associates of the local partner without the need for the charity or NPO to carry out an inspection or checks on the partner. Again, caution to that. And I'm not certain if you can see this last slide properly. I myself not seeing it directly, so please excuse me for that. And a request of administration costs not appearing to relate to the project, or which repairs unusually high taken into account, and it looked at what is being done. Maybe when you look at it, the money is way higher than it should be. Bear with me if I'm sort of rushing through this last stage. Now, you would want to know, and if I was sitting where you are, I would be asking the question of, yeah, all of this you're saying to me, but I don't believe what you're saying. Tell me something where you've had instances of persons actually committing the offense of terrorist financing. No, I'll say to you, the cases that I'm going to read here did not occur in Barbados. The cases that I'm reading to you did not occur in Barbados. Yes. Oh, sorry, neglected to say that when Barbados did its risk assessment in 2019, the rating for terrorist financing occurring in Barbados was low. All right, good. And for I had 2 cases for each, but because of the time constraints, I'm going to just give you one for diversion and one for false representation. And the first one is a large foreign NPO with activities in more than 160 countries was raising funds with the official goal of supporting various social causes. The NPO was previously suspected of having close ties with terrorist groups throughout the world. More recently, a number of countries publicly accused the NPO of having diverted funds from donations intended for humanitarian aid projects to the benefit of a long-established terrorist organization. The Bank of the NPO's domestic office sent STRs to the National FIU on a suspicious transaction made by the NPO and other organizations. Investigations by the bank and the FIU revealed the transactional links existed between all 3 NPOs. Doubts were raised as to the end use of the funds and the possibility that they had not been used to finance charitable work. Rather, it appeared that the funds had been used to finance terrorism, specifically to support the orphan children and families of so-called martyrs. Remember, I spoke earlier of money going to the family of those persons who would be suicide bombers. Law enforcement authorities are investigating the case. And the other one, in terms of false representation, a homemade bomb exploded in a house displaying a banner for a non-profit organization supporting orphan relief. An investigation found that the NPO did not exist and that a terrorist group was disguising its bomb-making facility as an NPO office. Law enforcement authorities seized a large cache of bomb-making supplies and weapons. One member of the terrorist group was charged and convicted of terrorism-related offenses. Those are the 2, I'll just use those 2 cases just to show you how, just a brief on how people manipulate nonprofit organizations for their benefit. And that, ladies and gentlemen, brings me to the end of the presentation. Please accept my apologies for the earlier break in transmission, which goes back to years ago when CBC used to have that sign up. And it was a normal service will resume shortly. So yes, please accept my apologies. And thank you for listening. And I am open to any questions that you may wish to pose.
Okay. Thank you very much, Mr. Rollins. Okay. And the panelists, thank you so very much. That was very comprehensive from both you and Casey. And I am here thinking that really and truly this requires really a face-to-face whole day session. Might probably be much better for this type of presentation, but I can take the feedback from the participants. So we have some questions in the chat. Casey has been answering some of the questions in the chat. I don't know if she wants to respond to any of those now. And if there are any questions for Roger, you can just raise your hand. And we would take the questions. Okay?
Hi,
Yes,
Ms.
ma'am?
Farley.
Yes.
I think I've answered.
Sorry, I'm
Oh,
not
but-
hearing you anymore, Casey.
I said if there's anyone who has additional questions, they can post them here, but I think I responded to most of them, if not all, in the chat.
Okay. Okay, we're seeing a question from Vernell asking if you're going to organizations to educate them on the rules and obligations of NPOs. If requested, and I believe, I'm not sure if that question is to both Kaipo and FIU. And then Fabiana has her hand up. So if you want to answer that question from Vernell, and then we would open to Fabiana.
Yes, we will accept or certain invitations to come to entities to educate persons on their obligations, educate and not advise. I just want to point that out. Just if there are resources in place that can come on a particular date, we will facilitate that. But I just want to also remind persons on the call that both the charity records and the nonprofit's record are public documents, and they can come and view their file once we're open. So a very necessary step that I think a lot of charities and nonprofits should take is probably to come and see your file. What is missing from your file, and try to bring your file up to date. Even if we send out default notices, if you have, very practical, if you have moved and we haven't been given notice of that move, when the default notice goes out, you're not going to get it. So it's very important that the record is as accurate as possible, and that's why we require you to make these filings as required.
Okay, so that is any particular time during the business day that they can visit, or?
Yes, we're open Monday to Friday, 8:30, 3 till 4:30, but the cashier closes at 3:15, so you're advised to get here before that time.
All right, Fabiana has a question, so.
Good morning, Ms. Farley. Good morning, everyone. Thank you very much for this presentation. I think it's quite useful because there generally is a lot of confusion about what some of the requirements are. And oftentimes people sometimes get wrong information. So thank you for this comprehensive presentations. I think I had asked a couple of questions in the chat. Some of them were answered. The ones from Kaipo were answered, but I had a few questions for the FIU relating specifically to recommendation 8 and the sector mapping and risk assessment. The recommendation 8 requires, as the gentleman, sorry, I'm forgetting your name right now, would have said, a risk-based approach. But it's not just risk-based for the organization itself, but risk-based approach to applying legislation across the sector. And my questions are, has a sector mapping and risk assessment been conducted for the sector? And is a risk-based approach being used for reporting for NPOs, or are we still using a one-size-fits-all approach for all organizations, regardless of the size or the level, the risk level of that NPO? Because the FATF recommendations paper states that within the FATF definition of NPOs, recommendation 8 is intended to apply only to those NPOs that pose the greater risk of terrorist financing or terrorist abuse. So that again goes back to my question of whether we have, or if we haven't yet, conducted that that sector mapping and using a risk-based approach, is that or will that be the approach going forward? Thank you. My question.
So, good morning again, everyone. Perhaps I can chime in here before Roger responds. I hope I am not jumping the gun on you, Roger. Please forgive me. But in terms of the assessment, when Roger spoke, he mentioned the national risk assessment that was conducted in 2019. And this risk assessment encompassed all of the types of entities in Barbados, including the nonprofits. In addition, there was a CFATF assisted assessment of the nonprofits themselves conducted, identifying certain nonprofits as at risk. So you did have a valid question, and I'm glad you raised it, Fabiana, because it is not a one-size-fits-all approach. Those identified as at risk would be subject to greater monitoring and measures as per the recommendation. However, there are certain things that still have to be in place, even outside of recommendation 8, that would require, for example, the basic information of the nonprofit to be available. For transparency purposes, it requires the statements of account, etc., to be filed. For international cooperation purposes, there are requirements that certain information be maintained and accessible to the authorities for the purposes of responding to international requests under that aspect. So it is a very complex framework at work, but the short answer is yes. So you would not find, and I also wanted to say, not to leave here, I don't want you to leave here shaking in your boots thinking the Attorney General is going to send somebody to knock on your door tomorrow to conduct an audit and to look into your affairs. That is not the case. The measures are there, and the measures are in the legislation, because we have to satisfy the requirement that we have these things in place should we need to use them. The need to use them then depends on, as you said, the risk, the activity of the NPO, what is going on the ground, etc. So it is not a situation where tomorrow somebody's going to wake up and decide we're sending all the auditors to all the charities in Barbados, and poor little Trinity's Church of Christ can't spread the gospel in peace because we're there knocking at their door asking for A, B, C, D, E, F, and G. That's not the case. It is done on a risk, as I said, a risk basis, and those at risk have been identified and are subject then to those additional measures. So I will just hand over to my colleague, Roger, should he now come in from the FIU's perspective.
Thank you, Tamisha. Just to add to what you said, it is not a one-size-fits-all, and that's why if you recall, it was said the risk-based approach is used. So once you would have used the risk-based approach and you realize, look, it's highly unlikely that my NPO or the NPO that I'm associated with, that it can be used for terrorist financing or any illegal activity, then technically you are exempted. No, I said technically you are exempted at that particular stage, because there's nothing to say that you would be involved in terrorist financing. I think the lady also mentioned risk-based approach to reporting. It's not a risk-based approach to reporting, is that where you suspect that the transaction is unusual or involves the funds that would have been legally obtained, you are obligated to report this information to the FIU. And that document, the STR that you submit to the FIU, is a record between only you and the FIU. The director of the FIU is a confidential document. You are not supposed to say, for example, you would have come across a donor and you realize this donor appears to be doing something wrong. This money doesn't appear to be legitimate, and you file the STR with the FIU. You don't tell the donor. That is kept confidential, and there's a penalty for tipping off. I think it's $50,000 or 5 years in prison. So you just go, you don't say to them, look, you know what, this money you sent to us, or we don't think this is legitimate money, I report you to the FIU. No, it's between you and the FIU. Now, if you had to file an STR with us, you are expected to keep that information relating to that STR for in excess of 5 years. Okay, there's some instances where the act refers to a business transaction. This is the MLFTA Act, which says that you're supposed to keep business transaction records for 5 years. But if you had to file an STR with the FIU, you are supposed to keep those records even after the 5 years would have been expired, or if the court would have instructed you to keep those records. But this is not, remember, it's not a risk-based approach to reporting. Okay, is that something has happened? You believe it is something is wrong, you file the STR with the FIU.
Okay, thank you. Sure, Fabiana is happy with the response. She has something in the chat. My question regarding reporting was about compliance related reporting, not STR related. Okay. You're saying it, Roger?
Yes, okay, all right, my misunderstanding, but I think I did not mention earlier that in terms of keeping the information as it relates to the STR. So thank you for well, at least guiding me along. I went the wrong. I look at it from different perspective, but it sort of worked out itself. Thank you.
Yes. Michael has a question. So Michael,
Good morning to everyone. Thank you for the presentation, the two presentations. I just wanted a little clarity on the PEPs, the politically exposed persons. I didn't fully follow what was shared, but I also wanted to find out if the trustees or directors in the charity or nonprofit are PEP, sorry, what is the expectation?
Okay. Like I said, the PEPs are sort of special persons, all right? And it is believed that from where they sit, that they have access to funds that the normal person would not be able to access, whether they're in office or whether they've exited office. So if you are setting up, you are receiving donations from a charity, from a PEP, we are asking you to look at the PEP of as an individual, do your due diligence on that particular PEP to be sure that the money that you are receiving is not tainted money, that is money that was legitimately obtained. Okay. if we look at certain countries outside of Barbados, I don't want to call countries, there would have been instances where persons would have allegedly taken money from the treasury and might have stashed it in other countries. Now, one way of getting that money back into the particular country, maybe when they would have left office, would have been to, all right, they be part of a charity. So the money comes from overseas back into the country to them. So it is there for, they are able to take that money and do whatever they want to do in the terms of it may move from the account of the NPO to, because they are in charge of the NPO, or they have a say in the operations of the NPO. So the money goes to the NPO and then it may find its way to back to their particular bank account or to a friend's bank account, that who in turn would revert the money to them. And I'm not saying that this is something creating this out of my head. These are things that would have happened, that there's documented evidence that actually occurred. So if you are dealing, like you said, if you are dealing with a pet, just be certain that you have all your information in relation to that individual and where the money the individual is providing to the charity, or if the person is sitting as a trustee, that what they're doing, the instructions that they're given in terms and making, that is all legitimate and is not for, let's say, illegal gain. Yes, that's it.
Okay, thank you.
Okay, Roger, while you are on that, I think Anne placed the question in the chat. Any tips on how to conduct due diligence on a pet?
Okay. There's something known as the, I think the attorneys here will be able to tell you, the reasonable man. Now, if you, and like I said, the charities, yes, you're there for a particular cause and you want persons to support you. But then you're looking at, if the pet makes a donation, and sticking to the pets, in terms, you can ask the person, now, if the pet donates $5, now I'm not saying to you that you need to go and check on that particular pet, because it comes back down to the risk-based approach. So when you, just like the financial institutions, and bear in mind, I am not saying to you that an individual needs to bring to you all the, in terms of the pay slip, the bank account, and so on. No, I'm saying you look at it on the risk posed to your trust, sorry, to your NPO. Person donates money to you, you're satisfied. Look, this is reasonable. If the donation, for example, is coming from outside of Barbados, all right, and you don't know who the person is the person supposedly sending the money, you can do a Google search. You can use social media to see if the person name pops up. It is okay, technically it's okay if the money is just coming to the, let's say, the NPO, and is a charity feeding homeless persons, or and so on. But if there's after you would have received the money, like I said earlier, you get a request from that particular person saying to you, okay, either return the money, or, for example, take X amount of the money and return the other portion to us, or divert that particular portion to someone else. Now, something has to be strange in relation to that. So And all of that relates then to your due diligence. You check on the individual, because the person may naturally send the money directly to the account, because I know charities sometimes they tell, okay, you can support by providing, we have an account at X financial institution, so you can supply that, you can go to the institution or wire the money to the account. So you need to go back and check on the particular individual. If the money stays with the charity, you're satisfied. Look, this is legitimate. All right. That there's nothing wrong with that. But as I said earlier, it goes back also to, you need to know your donor. Look to see the person actually who is supplying the money. If you're on Broad Street and you're soliciting money from persons, and the first person gives you $5, maybe let's say somebody pulls out $100 bills and donates to the charity there and then, as it stands there, I suspect that would be a one-off case. And the person would we'll have to look at that person and maybe ask the individual if further up the road the person comes and gives you another $1,000. That in itself would be strange, but that's just a hypothetical scenario there. But you can check on the individual once you realize, or you have a feeling that something is not right with this particular individual. I don't know if I answered you in terms of conducting due diligence, but like I said, it is done on a risk-based approach in terms of what you see in relation to your other donors and the chances, the risk that is posed to your charity from persons who may want to do some illegal act.
Okay. I think answer that it helps. So thank you very much, Roger. There's one recommendation coming. It looks like a recommendation coming from Fabiana. Sorry, let me just read that. And then we are going to wrap up, because I know that I have you here for a little longer than expected. But the information, I think, was very useful. It was a very informative session. Okay, so let me read what Fabiana said. Thank you, Mr. Rollins, for that response. But I was wondering if a sector-specific mapping had been conducted. I know there was a review, and a long list of organizations published back in 2019 in the papers, but can we say that we have an adequate picture? Can we say we have an adequate picture of the sector at the moment? And is this something that the sector can work with KIPO to conduct? Okay, so that question between the KIPO, I don't know if Ms. Rochester would want to make a response to that at this time, or if it's something to consider for the future. You can always get back to us on that.
Well, I can give a brief response at the moment. So thank you for that question. In addition to the list, so the list was only really a small part of the process, part of the activities that were done, again, in conjunction with the CFATF back in 2019. However, an assessment was done of the charities and nonprofits. The thing is that this assessment has to be current, because as you can appreciate, there are new entities coming and there are old entities going. And what really is necessary at this time is for the entities to get their records up to date. That is the necessity at this time, because that plays an important role in the assessment of the sector. So we need to be able to see the filings are being done in accordance with what is required, the statements are there, etc. Again, it goes to the transparency aspect, and it goes to the international cooperation aspect, which is also very, very, very important for us as a jurisdiction and our assessments by these bodies. I know we spoke a lot about the FATF, but there are also other assessments in play as well. However, in terms of working with the sector, of course, we appreciate the cooperation and the offers of assistance and collaboration, etc. And this is something we can correspond on further in terms of making sure that we are always up to date and accurate, and we have always we're always in a good position, continuous position, so that it was not just a one-off exercise. So as I said, we did identify the at-risk and the measures that were being applied to the at-risk that are not applied to the regular everyday, or I should say to the not at-risk entities. But the work continues. So this is something that we will consider, and we can have a discussion at some point. Fabiana, you can reach out to us. But as I said, the priority, the pressing thing at the moment is for the records to be up to date. So please take up Casey on her invitation to come and review the records, see what is missing, what is outstanding, what can be done to bring the records up to date.
Thank you so very much for that response, Ms. Rochester. And on this note, it is now almost 10 minutes after 12. And so I am going to thank you all so very much. I'm saying one more question. I was going to wrap up. I'll say one more question in here. If an organization is registered both as a trust and a charity, does it have to submit 2 sets of financial statements? And I believe that's one set of that's one statement. Because I remember Casey said earlier, all charities are trusts. Okay, so I think if it's, you have to submit the financial statement for the entity.
Yes, so one entity, if it's the same entity, one financial statement.
All right, thank you so very much. So let me just say thank you again to KIPO, to Ms. Rochester, and to the FIU, to Mr. Tate, for accepting our invitation to deliver this presentation this morning. And I am saying from the interest that it generated that maybe this is something that the ministry will have to be doing on an ongoing basis with KIPO and the FIU, you know, if there's any new information, so we can keep the sector up to date on what is happening, in addition to the invitations that I'm sure will be coming your way. But we will try to do our part as well and to keep the sector up to date. And as I indicated earlier, once I have the recording from RIT, we should have that soon, I will share that and any other information with the participants, those who participated today. So I just want to say thank you all very much. And I will also be sending the evaluation form with that. So please fill that out and help us to chart our way forward. And if there's any other particular type of training that you may need going forward, help us out with that. And any other comments that you would want us to know pertaining to the sector, what things that you would want to see happening for that. So thank you so very much again, Casey and Roger. All right. Forgive us for the little bleeps and blunders, but sometimes we have these things along the way. We try to do better the next time. So thank you all so very much for being here and for participating. All right.
Thank you.
You're welcome. Thanks for having us.
Roger, you didn't get any questions on cricket, so you're good. You can.
Yes. I'll be making it right next West Indies team.